This rule shall apply whenever a spouse seeks relief from the court in respect of one or more of the following matters. And then it lists 4 aspects. 1, maintenance pendente lite. 2, a contribution towards the costs of a matrimonial action pending or about to be instituted. Interim care of any child. And interim contact with any child. Those really are the 4 pillars on which Rule 43 applications are adjudicated. Ladies and gentlemen, a very, very notable absence, if we look at the wording of Rule 43 sub 1, is guardianship. As I mentioned, the 4 walls of Rule 43 are maintenance, contribution towards the costs of a matrimonial action pending or about to be instituted, interim care of any child, and interim contact with any child. First off, we start with maintenance pendente lite. Pendente lite, ladies and gentlemen, simply means pending the litigation. So this is a maintenance order that will be in place until such a time as the litigation is finalized. Maintenance can be divided up into 3 categories. First off, we deal with maintenance for minor children. Thereafter, maintenance for major dependent children. And then finally, our very favorite spousal maintenance. Right. What form can a maintenance claim under Rule 43 take? Number 1 is periodic payments of money to the applicant. Number 2 is periodic payments of money to service providers, i.e. school fees. Number 3, assets can be made available for use by the applicant, and that is Van der Spy versus Van der Spy 1981. It is a reported judgment that you can refer. Then let's look at the second thing that one can deal with in Rule 43, and this is a contribution towards the costs of a matrimonial action pending or about to be instituted. And some of the most bitterly fought Rule 43s that I've seen have been fought over this contribution to costs. The key principles in contributions to costs, I think, are 4-fold. Number 1, to get a contribution to costs, the applicant must show a prima facie case if they are the plaintiff, or they must show that they have a sound defense if they are the defendant. They don't have to prove that defense, they must just show prima facie. In other words, they must show enough facts which, if proven, would give them a valid case and or a defense. Then, incredibly important, folks, when you prepare your bill of costs for a contribution, or when you attack a bill of costs against a contribution, this has recently, I'll share anecdotally with you, saved my client's bacon. The contribution is only for the costs of the action. Interim applications are excluded. It used to be a very, very well established principle in our law that you are only entitled to future costs. However, we have had the apple cart thrown over with extreme malice by the Western Cape High Court. In 2 cases specifically, AF versus MF 2019 6 SA 422, which seems to suggest and flirts with the idea of allowing claims for past legal expenses. And then we have an unreported case of AG versus LG, which is referenced in Erasmus for those who would like to have a look at it, which really kind of goes the whole hog and says that you can claim past expenses, past legal costs under a claim for contribution to costs. Then let's go on to an interim care order in respect of any child. Care in relation to a child includes, where appropriate, within available means, providing the child with a suitable place to live, living conditions that are conducive to the child's health, well-being and development, and the necessary financial support. You remember I mentioned to you earlier regarding the maintenance, which really finds itself rooted in care of a minor child, and there is the evidence to that effect. Safeguarding and promoting the well-being of the child, protecting the child from maltreatment, abuse, neglect, degradation, discrimination, exploitation, and any other physical, emotional, or moral harm or hazards, respecting, protecting, promoting, and securing the fulfillment of and guarding against any infringement of the child's rights set out in the Bill of Rights and the principles set out in Chapter 2 of the Children's Act. Guiding, directing, and securing the child's education and upbringing, including religious and cultural education and upbringing, in a manner appropriate to the child's age, maturity, and stage of development. Guiding, advising, and assisting the child in decisions to be taken by the child in a manner appropriate to the child's age, maturity, and stage of development. Guiding the behavior of the child in a humane manner. Maintaining a sound relationship with the child, accommodating any special needs that the child may have, and generally ensuring that the best interests of the child is the paramount concern in all matters affecting the child. Once again, ladies and gentlemen, the Act talks about interim contact with any child, maintaining a personal relationship with a child. And if the child lives with someone else, communication on a regular basis with the child in person, including visits and being visited. And 2, communication on a regular basis with the child in any other manner, including through the post. I love that they still have through the post there. And then secondly, by telephone or any other form of electronic communication. WhatsApp and Skype and Teams and Zoom and all of these wonderful things that we have these days. So contact, ladies and gentlemen, is not simply a midweek visit and a every second weekend visit. It is much more than that. Yes, it is under subsection B, Roman numeral 1, in-person visits, but it's more than that. And primarily, it's not just visits. Contact is not visitation. It's not access, as they used to call it. It's maintaining a personal relationship with the child. And that then goes into the B section. A is the what is contact. Contact is maintaining a personal relationship with a child, and I would go so far as to say B is the how. And you do that by communication on a regular basis, either in person or by alternative means.